Good morning.
Good morning. May it please the Court. I'm Janet Pumphrey for Patricia Olsen. The Commonwealth's brief, of course, paints Patricia Olsen as an evil and vile woman who set up her own children, to murder her husband.
I take it that's what the evidence suggested.
Well, I'm going to ask you under your 33E plenary review to consider the other evidence, because there was plenty of evidence that Patricia Olsen was a loving and happy person, that she and Neil had a happy marriage. There was no motive for Patricia to kill her husband.
Isn't this all credibility? I mean, you have witnesses testifying to lots of different things, and it's really a question of credibility.
It is credibility, but I'm suggesting under 33E that you can look at this evidence. There's lots and lots of evidence that Patricia Olsen was a loving mother. She was a loving wife.
Well, we can't decide under 33E which evidence the jury should have believed.
Well, that's true. But you can consider the evidence to perhaps reduce the verdict to second degree.
Even if you were to, even with credibility, if somehow you could look at it, which I don't think you probably can, but I guess what struck me, discount the son and discount the daughter, but then you've got this telephone conversation that's taped between the daughter and her boyfriend in New York.
That's right. That's right. But it still says that the telephone conversation says that Christopher is going to do this thing. And that's about all it says. 99% of this evidence implicating Patricia comes from the children. As I said, there's plenty of evidence that Patricia and Neil were happily married and that she was devastated by his death. Although the evidence may be legally sufficient to have convicted Patricia of first-degree murder, through the testimony of her children, the evidence of her hatred of her husband was other than the testimony of her children, the evidence was relatively weak. Multiple witnesses testified that she loved Neil, that they were happily married, and that they were a loving couple. Nathaniel Newton never saw any problems between them, and they seemed happy. But Neil's brother, it's coming from Neil's own family. Neil had a good relationship with Patricia. Neil seemed happy with his marriage, which was excellent. Neil and Patricia seemed to be in love with each other. From Neil's own mother, Neil was supportive of Patricia's several business ventures, the video store, the restaurant.
Well, all of that evidence was before the jury.
It was. There was also plenty of evidence that Christopher and Amanda hated. They hated Neil and Neil hated them. According to multiple witnesses, Neil had thrown Christopher out of the house. He had forbidden him to come back to the house. He basically made Amanda eat cigarette butts because she was smoking. He beat them with straps. There was plenty of evidence that they hated him, and he hated them as well. They had significantly more motive to kill Neil than Patricia. She got first-degree murder, and after Christopher pled, he will be out of prison. Christopher and Amanda were both.
Did he plead too?
Perhaps Mr. Capeless can answer this, because I'm not sure if it was manslaughter or second degree. Okay. I looked through what I had last night, and I couldn't find it.
Could I ask you a question, just a fact question?
Mm-hmm.
Did the police give the defendant Miranda warnings on Tuesday, January 11th, when they spoke to her?
For the hours and hours and hours when they talked to her?
Yes.
I believe that they did, but I'll have to double check.
Okay.
What day was that? It was January.
Tuesday, January 11th. It was
11th.
When they went to her house.
Okay. I'll supplement. Amanda and Christopher were both liars, and they have motive to lie in this case. They're the only two witnesses that accused Patricia of wrongdoing. Christopher once told a tale about how he met members of a famous rock band, which wasn't true. Christopher's friend, Stephen, testified that he was an effective liar, a good deceiver. He lied to Abrielle about having $20,000 in the bank. Christopher admitted that he repeatedly lied to the police. He lied about hiding the rifle. He lied about in his first statements. He admitted lying to help himself. He admitted that he told his friend Stephen that he knew what to do to get out of the charges. He would blame it on Patricia. He generally admitted that he was a liar. Amanda testified that she withheld information from the police and lied to them in her first statement. She admitted to using cocaine and stealing money. She admitted that she was a suspect, and she was advised of her rights before she talked to the police. Both Christopher and Amanda were suspects in this case, and they hated their mother for abandoning them, and they had motive to blame her to save themselves. I would suggest that evidence from these two damaged children was sufficiently thin and unreliable.
And
Finally,
that was argued to the jury, wasn't it?
It was argued to the jury, yes. Finally, the Commonwealth's Commonwealth's theory of Patricia's motive of financial motive was effectively and persuasively rebutted. There's no doubt that the Olsens had financial difficulties, but Patricia put in evidence that she had financial difficulties before and she had always recovered. But most importantly, during the trial, Patricia sent her friend, Brenda Grant, to go to the house and get her prenup agreement, which was never found, and the $75,000 life insurance policy to show that the policy had been canceled. The police became aware of this. Patricia tried to put into evidence that Neil's life insurance premium had not been paid since 2003, but what she didn't know was that the life insurance actually had been paid, that the dividends were going to make the payments. So in the middle of trial, she sends this friend to go get evidence because she thought it was canceled and to rebut the fact that this was a financial motive, but she didn't know herself until the middle of trial that it actually was still in effect.
Well, did she testify to that she did
Yeah,
that?
yeah.
But the jury didn't have to believe her.
They didn't have to believe her, but she did testify to that. Second, the evidentiary issue, and as I was preparing for this, I realized that the cases in the Commonwealth's brief are exactly on point. The cases in my brief are exactly on point. The sole contested issue in this case was credibility, and in particular, Christopher's credibility. The heart of the defense went to the fact that Christopher was a pathological liar. The defense focused primarily and almost exclusively on an effort to show that Christopher had his own and overwhelming reasons for wanting to kill Neil. Christopher admitted in his own testimony that he was a liar. He realized after he was arrested that his only hope for relief was to persuade the Commonwealth that Patricia had instigated the murder. So at the beginning of the trial, on the 6th day of the trial, and then again on the 7th day of the trial, defense counsel offered proposed testimony from Trooper Thibodeau, who had, either personally herself or the other state troopers, had interviewed more than 22 fact witnesses in this case, and of the 22 fact witnesses, of the more than 22 fact witnesses, 22 of them, in their statements to the police, had said Christopher is a pathological liar. Defense counsel argued that 90% of the persons the police interviewed expressed the opinion that Christopher was a liar.
So you wanted to call Thibodeau Trooper Thibodeau, to testify to the witness's reputation in the community?
Reputation in the community.
Based on her reading police reports of other interviews? How is that proper?
Exactly. Well, I would suggest that what the court said at the time was that it was not admissible because this was obviously a policeman and not a member of the community. But I would suggest that why does it have to be a member of the community?
Don't our cases say that? They say that it has to be somebody familiar with the reputation. You just can't send someone in.
Well, I would suggest that the Trooper Thibodeau, through the statements to the police, was as familiar through these statements as anybody else would have been.
Do you have any authority for the proposition?
Well, I don't, except because I really don't have any authority other than I just don't see how a police officer is necessarily different from a community member at this point.
But then you could do that in every case. Just send somebody in. I mean, the defense could send in and investigate him to the community. You wouldn't get, I mean, you'd get strangers.
There is, in the transcript, and it's in volume 6 around page 7, there is a lot of discussion as to whether this is just hearsay, and it is hearsay, but it is, I would suggest, credible hearsay because it's statements by fact witnesses, disinterested fact witnesses to the police.
But I take it that one witness named Abrielle, I think it was.
Yeah, that's the one that came in.
Did come in, and a foundation was laid for, I take it, it's her, Abrielle?
It's a Stephen.
It's a he?
It's a he.
For his familiarity with Christopher's reputation for honesty and veracity in the community, he said that he did have a reputation for honesty, or he did have such a reputation.
Right.
And Abrielle testified that his reputation in the community is very poor and he's a liar.
He's a pathological liar. Yeah.
The evidence came in on a proper foundation.
It did come in. But I would suggest that it would be have been much more powerful evidence, and this is the crux of the defense.
Of course, if a police officer came in and said read a bunch of reports, but
every single person, 90% of the people they talk to, and it's on transcript volume 6, page 7. Defense counsel says that these are the kinds of things that were in the police reports. I told them I knew he had been lying to me for a long time. He lies about everything. He's a liar. He's a pathological liar. I knew that these were lies. I knew that you never knew when Christopher was telling the truth. I knew something was not right about the kid because he was lying all the time about bizarre stuff.
Were you barred from calling any other member of the community in on this question, or was it just the trooper?
22 people?
Not barred, but the problem with calling them was really that a witness, say witness 2, can't testify to specific lies from witness 1.
But I mean, the rule is designed to allow somebody to come in who has familiarity with a person's reputation for honesty and veracity and testify about the reputation. That's what's permitted.
Yeah.
And that took place here.
That's right. That's right. And it did come in through Stephen Abriel's testimony as well. But I suggest it would have been very powerful through the police, through the trooper. And it was
sort of abusing the trooper's credibility because this is a police officer. It must be more credible, and the police officer has no basis in the community to make this judgment.
But not so much because he's a police officer, but because the credibility of particular statements made to police officers. I mean, these are hearsay statements, but made to police officers by disinterested fact witnesses gives them some credibility, more credibility than most statements. So I would suggest that these.
Well, in any event, the defendant, or Christopher himself, got up and said he was a liar.
Christopher himself got up and said he was a liar. Yes, he did. Let's see. And Christopher's testimony came in. I would just suggest that there could have been much more testimony, especially through the trooper. This was the heart of the defense, and the trial court's refusal to permit this testimony directly frustrated defense counsel's ability to present all the evidence. And finally, the graphic photographs, again under 33E analysis, the medical examiner testified that and the graphic photographs came in to Neil's face was deformed and depressed. The photographs
there was an extreme atrocity or cruelty theory here.
It was, but I would suggest that just the fact that she was not the person who did the murder herself.
But it's a joint venture.
It's a joint venture. Yes, it is. It is. But I would suggest that under your 33A analysis that the graphic photographs were highly prejudicial. Thank you.
Thank you.
If you may please the court, good morning, Your Honors.
Good morning.
District Attorney David Caples appearing on behalf of the Commonwealth. The main problem with the defendant's theory in this court, whether arguing upon the facts and particularly on the Section 33 argument, is that the argument is that the Commonwealth's whole case was based upon Christopher and Amanda, that they hated their father, Neil, and that therefore they accused him. The problem was this was not supported by the evidence in any way. First, they did in fact hate him, but the Commonwealth said Christopher was the one who shot and killed his father. What was missing was all the evidence pointed that they hated Neil, but the opposite about their mother. Amanda didn't have the greatest relationship with her mother, but the evidence indicated that on that very weekend, a number of phone calls between the two of them initiated by the mother calling her daughter Amanda. And Christopher, of all people, was the one who was wholly dependent upon his mother for his life. She was the one who was supporting him, keeping Neil away from him, covering up for things for him. He had every motive in the world not to wrongfully blame her for something that he had done. And in addition to their testimony, there was considerable corroborating and additional evidence to support the Commonwealth's theory that Patricia Olsen was the instigator of this and had convinced her son Christopher to murder his stepfather Neil. First, Pat Prendergast, a family friend, as well as Charles Wilkie, who was the boyfriend of Amanda's boyfriend's mother over in New York. But both of those people came in to testify that Patricia Olsen had approached both of them about having Neil killed, either doing it themselves or getting someone to do it. She asked Wilkie on the theory that he had at one time belonged to a motorcycle gang, and so it asked him. There was, as the court had brought up earlier, the recorded phone calls between Amanda and her boyfriend Andy while he was incarcerated, which showed not just that she knew this was going to happen, but that the source of her information was from her mother, Patricia, because each one of those phone calls the telephone record showed, immediately came after a phone call from her mother. And that was what was important of showing this, of how increasingly the information, it's going to happen. It did happen. She knew that it was a shooting long before the police themselves had discovered that, and before she had had any contact with Christopher, the evidence showed. Additionally, the tracks in the snow, showing that Christopher, as Christopher had described, that he had gone back on the night following the murder to get the gun that was held in the house and remove it from the house after the police had been there, after Patricia Olsen, his mother, had talked to them and told she knew nothing about it, and then had hidden the gun. And then, of course, there was her own consciousness of guilt. You know, without prompting, saying to the police, oh, I was asleep and I took some medication that caused me to be drowsy. And, oh, there isn't any life insurance. I'm not going to get anything out of it. And, in fact, the further investigation showed that, in fact, after the time she claimed that she was asleep and couldn't have known that the shooting was taking place in the stable which adjoined the house, that, in fact, she made several phone calls and that she had accessed her own voicemail. But even more importantly, that she had gone ahead and erased all traces of incoming or outgoing calls from that very day. But the records show that there were incoming and outgoing calls the day before, the 2 days before, and the 2 days afterwards, which not only contradicted the story that she had given to the police unprompted, but also showed that she had something to cover up. And then finally was her contrived story about discovering Neil's body in the stable. Because the evidence showed, and particularly the jury had an opportunity on the view to see the structural layout. She claimed that she had come up and that she had seen Neil's feet protruding through the doorway and had dropped the breakfast that she had for him, the coffee cup and the paper bag holding the breakfast sandwich. But in fact, the evidence showed that where those two items were dropped, and the photograph showed the jury where they were found and how that, she couldn't have even seen into the stable at all. And then further claiming that all she saw was his leg, she touched him and saw stars, never saw blood, claimed she never saw blood, which was an important of why the photograph showing that scene had to describe that anyone who came anywhere near that scene would have seen the blood in all this and would have realized that, in fact, this was a horrible death. Not that he had died and perhaps had had a heart attack, but obviously something violent had clearly happened to him. And again, the life insurance claim. She repeatedly said there was to a number of people, not just to the police, there was the prenuptial agreement, which was never produced, and attempts were made to try to discover this, that was never produced, and that she had no life insurance, when in fact there was. And contrary to what's been argued here, she did not try to find the life insurance to show that in fact it had been, it had lapsed. In fact, what she was trying to do was get the check on the claim that she had made on that cashed and the money produced to her. That she had asked a friend to go and do this because she was being held in lieu of bail at this time and could not do that. And this woman contacted the investigators who then followed up with it and found that, in fact, this life insurance policy, along with her husband Neil's his pension, totaled $175,000. And the facts as they were laid out and the evidence showed to the jury was that the only way that she could have access to that money was if Neil was dead, not if they were divorced. He would have gotten the life insurance, which was in his name, and obviously the pension, which was in his name. Only through killing him was she going to get it. And in fact, there was no rebuttal of, in fact, this financial motive. It was very clearly laid out that, in fact, this had been spiraling downwards for years. She had to enlist a $40,000 loan from Neil's brother, which he had to clear up. And how long was it going to be before the brother at some point would let Neil know about this? And these were failed businesses. This was very clearly shown. And her prior getting out of trouble, she declared bankruptcy. That's how she got out of it before. And so now this has happened again. Neil doesn't know about it. And while it may be difficult for somebody to understand that, in fact, a wife would see about having her own husband killed, The other evidence indicated this is a woman who didn't care about anybody. And there was not conflicting evidence about their relationship. What was very clearly presented to the jury where witnesses were brought forward, not to say, and particularly those who had association with Patricia Olsen through the business, those who worked for her primarily, was not to say that they knew that Patricia and Neil had a good marriage, but to show some of them that Patricia said they had a good marriage and that she loved Neil. Then others of those, in an equal position, she said to them they did not have a good marriage, that Neil was horrible to her and abused her emotionally and psychologically, demonstrating that, in fact, she had no concern about him. It was only what she thought people would believe or she could use from them and manipulate them, whether they would feel sorry for her or thought that she was a good wife. And that's what this was about. And again, the evidence was necessary not only just to prove that, in fact, the photographs to demonstrate extreme atrocity or cruelty, also to show that, in fact, this was premeditated, that was the use of the weapon that was carried out. But I think that if going back and looking at the defendant's own argument about this case, if the Commonwealth hadn't brought in the photographs and the description of that scene, and in fact what had happened to Neil and the way in which he was killed, the defendant would have brought it out. Because a large part of the defendant's argument was this was an emotional killing. He didn't just shoot him in the head and walk away. He shot him repeatedly, emptied the rifle into his head, and then apparently took the iron bar and smashed in his face additionally. And so that was argued. While this evidence came in and the witnesses who had identified these photographs at the scene, particularly those, the expert who had identified the blood spatter pattern, were continually asked by defense counsel about how this was a horrible scene, and this showed an emotional rage that was attached to this. And so, contrary to what the defendant is trying to argue to this court, to the jury, it was argued that, in fact, this was evidence supporting the defendant's theory that this was emotional, that Christopher had done it. Again, as I say, what was lacking here was any motivation against Patricia Olsen, the mother, on the part of Christopher and Amanda. But more importantly, they had all the other evidence to support the fact that, yes, Christopher had done it, but it was at the behest of the mother that he did it. She was the principal involved in this. He, in fact, was the weapon and not merely the perpetrator. And to answer the question that was raised earlier, he pled guilty to second-degree murder.
Thank you.
Unless there are questions from the court. Thank you.
Thank you.